Hearing the appeal, FirstPort Property Services Limited against Settlers Court RTM Company and others.
Yes, Mr. Harris.
My Lords, my Lady, I appear for the Appellant FirstPort Property Services, together with Ms. Zia, my learned friends, Mr. Loveday and Ms. Scorley appear for the Respondent RTM Company. You'll have seen the other respondents are leaseholders and do not participate in the appeal, and the Association of Residential Managing Agents appears by way of the written submissions of Mr. Cohen. You should have, I hope, two supplemental bundles that were filed. One last week, which contains a statutory instrument that had been requested, and then more recently, a second supplemental bundle that contains an authority called Pineview. That should have been at page 519 in the core volume. My apologies, the pagination for it is there, but the image appears to have disappeared. So that is where we find that. You'll have seen this appeal raises one superficially simple question. Does an RTM company, in respect of a single building on a wider estate, acquire just the right to manage that building, or does it acquire the right to manage the communal parts of the wider estate on which it sits to the extent that the leaseholders enjoy rights over them? And you will have gathered that this simple question has a very significant practical consequence in the context of this case, but also for many other sites, as the submissions of the intervener allude to. It may not be particularly straightforward to establish the answer, but of course both sides consider their proposed solution is the only possible answer. Now, the route this case has taken has two slightly unusual features. Firstly, it's a leapfrog appeal from the upper tribunal. You will have seen the courts below were bound by a decision of the Court of Appeal in Gala Unity on this central point. But secondly, because whilst the appellant has been somewhat rehearsing some of the arguments before you in the lower courts, the respondent has not had to substantively deal with them. They can rely on Gala. In the FTT, it was conceded by FirstPort that the tribunal was bound by Gala. In the upper tribunal, the question is whether Gala could be distinguished or found to have been decided per incuriam. And the net result of that is that the arguments against the appellant on the substantive issues were only really made known a few weeks ago upon receipt of respondent's written case. That is not a complaint. It's just the way that the proceedings have taken effect. It does mean you don't have our full answer to the respondent's written case. And in many ways, this is sort of the first and last round of the arguments in that regard. So I will respond to the respondent's key points in oral submissions this morning. Now, whilst I'm very happy to do a more detailed opening on the operation of the RTM scheme and the facts of the case, I don't want to take up time unnecessarily. And I anticipate you've had the time to read our written cases and to consider the Court of Appeal's decision in Gala.
On that, we have, and our tentative view is that the time estimate may be a little generous for
My Lord,
this case, such that if counsel can speed along and get us through in a day, that would probably be sufficient.
My Lord, I think we're probably in agreement on that. We'll see how. I don't think we want to commit 100% to that, but our initial time estimate was indeed 1 day. I think the court has allowed a day and a half,
yes,
which is comfortable, but that should be possible.
Yeah. Well, don't feel you have to spend the whole day and a half.
Understood. Now, there are 5 matters I want to focus on in my submissions this morning. Firstly, I propose to turn to the statutory purpose of the scheme, because plainly the answer to this appeal turns on one construes the 2002 Act in a way that gives effect to Parliament's intention. Secondly, against that purpose, I want to provide my overarching response to the respondent's suggested approach. Thirdly, I want to turn to the meaning of a pertinent property and premises. You'll have seen that both parties make fairly extensive reference to other statutory schemes that use similar wording around a pertinent property, or other schemes that achieve related but different aims. That's the respondent's case by way of analogy, and you're going to need to decide whether those analogies are helpful or indeed relevant, and the extent to which the RTM scheme needs to be construed in its own right against its own purpose. Fourthly, I'll touch briefly on the alternative constructions advanced by the appellant. You'll have seen there are 3 possible solutions advanced in our written case. And then lastly, having dealt with those points, I want to turn to the practical issues and highlight the specific issues that arise in this case and how they come to be resolved based on each of the parties' cases with very different outcomes. The obvious relevance of that is the absurdity point. So if I can turn to statutory purpose, first of all, the 2002 Act starts life for present purposes by way of a draft bill and consultation paper. If one turns to page 621, one finds the draft bill. The bill appears first, the consultation paper later. Turning down 2 pages at page 623, you'll find the ministerial forward that introduces the consultation and the bill. It doesn't make specific reference to the right to manage. It was introduced by David Locke, then Parliamentary Secretary, and Nick Rainsford, Minister for Housing and Planning at the time. I'll return to one feature of the draft bill later, but for now I want to take you to the consultation paper and just highlight a few points in there. To do that, one skips forward to page 682. I could just highlight a few passages in here. At paragraph 5, at the top of the page, you'll see the Residential Leasehold Reform Consultation Paper of November 98 proposed introduction of a new right for a majority of the leaseholders in a block of flats to take over the management of their block. And then at 9, the government therefore considers that a new right is required to allow leaseholders to take over responsibility for the day-to-day management of the block in which they live. The proposals set out in the draft bill are intended to achieve this. At 10, the main objective is to grant residential long leaseholders of flats the right to take over the management of their building collectively without either having to prove fault on the part of the landlord or to pay any compensation. The procedures should be as simple as possible to reduce the potential for challenge by an obstructive landlord. And then at the end of that paragraph, at the same time, the legitimate interest of the landlord in the property should be properly recognised and safeguarded. 11, except where specifically provided to the contrary, RTM is not intended to override any aspect of the lease other than to transfer relevant functions or responsibilities to the managing body. Turning over the page to paragraph 15, this is under the heading eligibility criteria. Premises would also include any associated parts, such as garages or gardens, which are for the sole use, emphasising sole use, of the residents of the block in question. And scrolling down a couple of pages to paragraph 22, the right to manage as set out in the draft bill has been prepared on the basis that the right will apply to leaseholders of flats on a block-by-block basis. This would allow individual blocks on a commonly managed estate to take on responsibility for their own management and thereby remove themselves from the overall management scheme for the estate. It applies to a single block, and we'll look at an authority on that point in due course. One then scrolls down a little way to page 694. Paragraph 69. This is under the heading Management Functions of the RTM Company. Where a management function fell to the RTM Company, the landlord would not be entitled to carry out that function. This provision should prevent duplication of responsibilities and dispute over who should deal with particular matters. It was not intended there would be dual management. It was intended there'd be a clear split. Down to page 698. Under the heading Arrangements where there is a tripartite lease or where the block is part of an estate. At paragraph 88. In certain cases, a block of flats may be part of an estate of properties with all blocks enjoying a number of common facilities. These may include, for example, a car park or gardens. Where that is the case, the RTM company would become responsible only for the management of the block for which RTM had been exercised. Responsibility for the management of the common facilities would remain as allocated under the lease, as would the liability of leaseholders to pay towards the costs incurred. That is the position that we advocate for in this appeal, to give effect to that intention. Lastly, just over 2 pages, paragraph 102.
Just before we leave page 698, do the papers include any responses to question 16?
They don't, and we haven't been able to find them, is the answer to that. But what we can do is point to the draft bill and the difference between the draft bill and the Act, which I'll take you to in a moment. Page 700, paragraph 102, it's the second sentence I'm taking you to, where the exercise of RTM caused leaseholders to have to pay separate charges to the landlord and to the company. The leaseholders would be able to exercise the same rights in respect of both charges. So again, this is emphasising the idea, as we say should be the position, that the RTM company takes over management of the block, the leaseholders pay the block costs to the RTM company. The estate...
I'm very sorry, could you just tell me which paragraph you're now referring to?
I'm on page, paragraph 102.
Thank you very much.
Second sentence. So the idea that the block costs are paid to the RTM company, the estate charges are paid, in this instance, to FirstPort. There'll be 2 charges payable. So that's the consultation paper. Now, the version of the bill that was introduced into Parliament differed slightly from the draft bill you find in this paper. But the only material difference for the purpose of this appeal is the wording of what is now section 71. That, I think, is agreed. There were no material changes.
What was the wording that accompanied this consultation paper then?
The wording that accompanied this consultation paper is the draft bill that you find at page 626 onwards.
And what does that say?
My lady, the best way of seeing the difference is if one turns to page 116, that's the respondent's written case at paragraph 52. And helpfully we can see what was originally clause 53(1) becomes, because of changes to other provisions that are not relevant, section 71, and you can compare and contrast the 2 there. So the original reference is to the chapter having effect for the purpose of conferring the right to manage premises, but without telling us what the right to manage is. Section 71 says it makes provision for the acquisition and exercise of rights in relation to the management of premises, thereby telling us what the right to manage is. The problem with clause 53 is if one looks at 53 sub 2, which is at the top of the next page, you'll see there it says that right is exercisable subject to and in accordance with this chapter. It's referred to in this chapter as the right to manage. So we have 2 provisions that both say the right to manage, but it doesn't actually say what the right to manage is, whereas section 71 does explain what the right to manage is.
But in the original bill, was there any provisions for anybody telling anybody what rights were being taken over by the RTM, or how the service charges would be split, or whether the original company had any choice about whether they still wanted to be involved in the management of the common park? There
is no material difference between the draft bill as attached to the consultation paper and the Act as enacted that is material to this appeal, other than this difference that you see on page 116. That is the change that's made between the draft bill and the version of the bill that was introduced to the House, and there is no material change as it passes through the House and is enacted. suspect, perhaps not unsurprisingly, it didn't attract that much attention at the time, is the reality. Now, the respondents' cases, that change that you see on page 116 paints what's described as a revelatory picture in circumstances where they say section 71 is critical to the outcome of this appeal. The appellant's cases that we disagree. We say section 71 is purely introductory. It's in the Act under the heading introduction. It's non-operative substantively in nature. In short, we say virtually nothing turns on the effect of section 71 because it really doesn't have much effect. It's just an introduction. The Act would still function without section 71 being there. I may come back on that point once I hear from my lawyer friend as to why section 71 attracts so much importance, because I may not fully understand the point. You'll see some conjecture in the respondents' case as to why there is that change. That's at paragraphs 53 and 54 of their written case. All any of us can do is speculate. The respondent says the reason may be to more closely follow the reading of the 1987 Act, which they then draw on by analogy. I say, as you see, it's really just to tidy up the drafting, to introduce the concept of what the right to manage is, i.e. it's to provide for the acquisition and exercise of rights in relation to the management of premises. And that wording is very similar to the wording you'll see in section 96(1), which really is much more central to the outcome of this appeal. It was tidying up and it was to reflect section 96(1). So it's similar but different wording from the 1987 Act. The only other point I wanted to make on this change in wording between what was clause 53 and section 71 is just to take you to a note in Bennion that we find at page 612. The second substantive paragraph. The drafting of a bill may change for a variety of reasons that were not intended to alter its meaning. For example, after a draft of the bill has been published, the drafter may have time to reflect on it and decide that the drafting could be improved, or there may be a change in the drafter in charge of the bill between publication of the draft bill and introduction of the bill into legislature. There could be many reasons. It's dangerous to draw a conclusion.
Well, do we know when this change occurred, at what stage? Or?
We know the change occurs between the draft bill and the consultation paper, which in fact was a second consultation, and it being introduced to the House. And that, you don't have a copy of the version introduced to the House. That's an agreed fact as between us. There was little in the way of relevant debate on the RTM provisions, so far as is recorded in Hansard, anyone's been able to find at least. There was some I think a lot of the focus was on the Commonhold provisions in reality, and there was a more controversial right to enfranchise and things like this. RTM really passed under the radar. There was some discussion about whether to enable a right to manage company to acquire the right to manage an entire estate of buildings, and an amendment was proposed, but it was withdrawn. And you can find the relevant exchange relating to that on page 585. It's recited in a case called Triple Rose that I'm going to return to and introduce later. If I can just take you to this paragraph for now. It's paragraph 57, halfway down page 585. So Lord Whitty there is recognising and pointing to the complexities of RTM applying to more than just one building. That's not just in relation to the complexities that we refer to in this appeal. There's all sorts of other complexities, such as how voting rights would operate. You may have blocks of differing sizes, differing competing interests in different blocks. It is complicated. I'm not going to go into that now because it's not central to this appeal, but you can see it all considered in the Law Commission's work on the right to manage, which is contained in the bundle if you want to explore that further.
Well, it's really just about what was said to be a self-explanatory amendment that wasn't introduced.
Well, yes. Really, all it shows for present purposes, there was some thought about extending it to something beyond a block,
yes,
and it didn't proceed. That's really all I say is relevant for today. So if I can summarise on purpose, it's clear that the intention was to pass effective control of management of the block in which they live to the leaseholders automatically, but not to pass control of the shared estate. The relevant context to the exercise of the right to manage is that leaseholders are likely to be unhappy for whatever reason with the current management. And I say that in light of all the context and material, we should work from three assumptions in particular when we're construing the Act. Firstly, that Parliament cannot have intended a scheme whereby the parties are forced into some element of cooperation. Secondly, it cannot have intended a scheme that was any more complex than necessary. Whether it achieved that on any of our constructions is...
Some element of cooperation with whom? Anyone?
So an element of cooperation between the right to manage company and the incumbent manager. That might be the landlord, it might be, as with FirstPort, a tripartite manager. It could be a court-appointed manager. But an element of cooperation between the person currently managing the block and the RTM company, because the relationship's broken down. That's why people are exercising the right to manage usually, is they're unhappy with management. My second point was that...
And that wouldn't just be with the quality of management, but the cost-benefit of management, for example.
It could be all manner of reasons, but usually somebody's dissatisfied with something. Insurance is a common thing cited. People think they can get insurance cheaper, which often they can initially. But there's lots of possible reasons. The roof might have been leaking for years and they think it shouldn't have been patch repaired and they think they can do it better. Whatever. There's lots of reasons. And another reason might be simply that you've got a tripartite manager, not a big commercial manager like FirstPort, but a management company that for whatever reason has ceased to exist. It could just be a breakdown in the mechanics.
But the scheme as enacted doesn't enable you to pick and choose which of the management functions under the lease you acquire. You have to acquire all the management functions under the lease.
Absolutely. The problem, and that's right, and so there isn't this dual management issue with the block because you take over all the management functions on the block. The problem is the wider estate, because there, according to Gala Unity, you have shared management because the landlord's still responsible to manage the estate for all the other blocks on the estate, but the RTM company is apparently managing the estate as well. So they are forced into cooperation. And if they can't cooperate, that's why we're here. So my three assumptions, I say, firstly, can't have intended cooperation. Secondly, can't have intended scheme is any more complex than necessary, although there are always going to be complexities, I fear. And thirdly, it must have intended a scheme that was commercially workable. So not one where the RTM company is forced into an obligation in respect of which it has no income stream, or one that would result in the incumbent manager being unable to recover its own cost of outlay, as is the position here. Those are the three assumptions I say we should take in terms of statutory purpose, if those assumptions can be met when one reads the scheme. If I may, I'm now going to turn to responding to the respondents' overall approach as set out in their written case. It's the second of the 5 points. Overall, we say The outcome of the respondent's approach is inconsistent with that intended statutory purpose, and there's nothing at all to suggest that that purpose changed between the consultation paper and the final legislation. As I say, very little changed whatsoever from start to finish other than that section 71 wording. And the approach of the respondents really means that one disregards section 72, which we'll turn to, so far as the issues in this appeal are concerned. Now, section 72 is the one that sets out the qualification criteria for the premises, self-contained building or part of a building with or without a pertinent property. That's central to the Gala decision. Respondent's case, as I understand it, is that once the right has been acquired, all management functions undertaken by the landlord or the manager previously become functions of the right to manage company, qualified by the need for them to be functions relating to the premises. But it's very difficult to see under a lease why there would be management functions that don't relate to the premises on the respondent's wide view of relating to. So it's everything, every management function under the lease passes on the respondent's case. And the focus in their case is on section 96.1. We're going to look at this a lot, so we probably should just turn to it at this point. It's on page 328. So what 96.1 is doing is saying management functions, and management functions, I should say, are defined at section 96.5. Relatively all-encompassing, anything that might be in a service charge would be shorthand. And 96.1 says that section 96 and 97 apply in relation to those management functions relating to the whole or any part of the premises. And on one analysis, this entire appeal turns on what do the words relating to mean. Respondent says it should be given a wide meaning, we say it should be given a narrow meaning. So their solution by doing that, by saying section 72 just deals with qualification criteria, then we can park that, we forget section 72. Once you've acquired the right, we turn to section 96.1, and section 96.1 tells us which management functions transfer. It is a neat and attractive solution that respondents put forward. It also happens to be the same as our third version that we put forward. The difference between us is what does the word relating to mean? And the problem with the respondent's solution by saying relating to should be given a wide construction is it provides a neat and attractive solution to only half the problem. It doesn't work, and it's demonstrably wrong. Fundamentally, it doesn't serve the absurdity point that I'm coming on to in due course. It's as commercially hopeless as the outcome we get from the Court of Appeal's decision in Gala. It gives no answer to the difficulties in this appeal, save by way of effectively shrugged shoulders. That's why we say it's only a solution to half the problem. Secondly, it doesn't accord with Parliament's intention that they only acquire the right to manage the block and not the wider estate. Thirdly, the respondent's solution seemingly places too much emphasis on section 71. I've addressed you on that already. And fourthly, the real emphasis is upon section 96.1. But the way in which the respondents put their case is to say relating to should have a wide meaning, and they say that by analogy with a case called Corsand, and I say that analogy is flawed, so I want to deal with that point now. I say over-reliance on the 1987 scheme, Part 2, for the appointment of a manager can't be justified. And to explain that, I think we first of all need to look at how the 1987 scheme works. If one turns to page 300, one only needs to look at three sections. It's a relatively simple and straightforward statutory scheme. At 21.1, The tenant of a flat contained in any premises to which this part applies may, subject to the following provisions of this part, apply to the appropriate tribunal for an order under Section 24, appointing a manager to act in relation to those premises. You'll see at subsection 2, this part applies to premises consisting of the whole or part of a building if the building or part contains 2 or more flats. Mirrors the qualification criteria in the RTM scheme. Section 21(4)(b), you can see an application for an order may be made in respect to 2 or more premises to which this part applies. You can apply to appoint a manager in respect of all the blocks of the Virginia Key estate on which Settlers Court is situated. And at 6, subsection 6, an application to the court for it to exercise in relation to any premises, any jurisdiction to appoint a receiver or manager shall not be made by a tenant in his capacity as such in any circumstances in which an application could be made by him for an order under Section 24. What that does is substitute this statutory scheme in place of the former, or in place of the jurisdiction of the High Court to appoint a receiver or a manager in respect of property if it considers it just and convenient to do so, which is the way in which these things used to be resolved prior to the 1987 Act. So it is this scheme operates in substitution solely in respect of flats, blocks of flats. You're precluded from going to court. You have to go to the tribunal. So that's section 21. Over the page, section 22 provides that before you can make an application for an order, you must serve a notice. That notice will be served on the landlord, or if it's a tripartite lease, such as here, you would serve it on the named manager. And that notice has to set out a number of things, but essentially it must set out why you consider the current manager is at fault. What have they done wrong? It's a fault-based scheme. We can then skip over to section 24, page 303. Subsection 1, the appropriate tribunal in England, the first-tier tribunal property chamber, may, on an application for an order under this section, by order, whether interlocutory or final, appoint a manager to carry out in relation to, I underline, any premises to which this part applies, any functions in connection with, we don't have that wording in connection with in the 2002 Act, in connection with the management of the premises, or functions of a receiver, or both as the tribunal thinks fit. It's a discretion, the tribunal may, and it's in wide terms in relation to, in connection with. That wide discretion is limited at subsection 2. It may only make an order, in essence, if the tribunal is satisfied the existing manager is at fault. Then over the page, subsection 3, the premises in respect to which an order is made under this section may, if the tribunal thinks fit, be either more or less extensive than the premises specified in the application on which the order is made. So the application might be made in respect of 2 out of 3 blocks. The tribunal may take the view that appointment of a manager is only going to work if it appoints a manager in respect to the 3rd block and gives rights over the estate so as to make the scheme of management work. Procedurally, if it was to do that, it would no doubt require notice of the application to be given to the tenants of that other block and enable them to participate.
But under that regime, it's very clear that the tribunal can appoint the manager to carry out some but not all of the functions under the lease, and therefore you have in subsection 5 provision that empowers the tribunal to include in the order all the consequential provisions that you would need to split the service charge, decide who's going to perform the residual functions, but we don't have any of that in the present regime.
Quite so, yes. It's a very, very wide power that mirrors the High Court's prior jurisdiction. They're very different schemes. There's a case called Bentham, which you'll find at page 369. Don't want to dwell too long on it, but it's a recent illustration. It's a 2021 Upper Tribunal decision of Judge Cook. And that was a case with relatively unusual facts because there was a tribunal-appointed manager under the 1987 scheme, and the leaseholders of a block wished to exercise right to manage that they could take over management from the court-appointed manager.
What was the name of that case?
Bentham, my lady. It's page 369. I just want to take you to a couple of sections in there. Page 371, paragraph 2. Judge Cook notes they are very different schemes, they being the RTM versus the appointment of a manager scheme under the 87 Act. The 87 Act scheme enables a tribunal to appoint a manager when, for example, the landlord is in breach of its obligations to the tenants. By contrast, the 2002 Act enables an RTM company to acquire the right to manage on a no-fault basis when the correct procedures have been followed without any requirement to show that anything has gone wrong or that any obligation has been broken. And down 2 pages at paragraph 11, and this is a very important distinction in my submission, the powers of a manager derive from the FTT's order and not from the lease. They may be even wider than those of the landlord. That follows from a case called Maunder-Taylor and Blackriere. They may extend to property over which the relevant leaseholders have rights, but which is not demised to them. That's Corsand. And sections 24, 4 and 5 enable a wide range of orders to be made, for example, transferring to the manager rights and liabilities under contracts to which he or she is not party, requiring the landlord to pay the manager, enabling the manager to prosecute causes of action, and so on. As Mr. Bates put it, the manager is neither the landlord's man nor the tenant's man, but is appointed by the tribunal to manage the property in whatever way is needed. That's the point my lady was making. And then lastly, just over the page at 374, paragraph 18, chapter 1 of part 2 of the 2002 Act sets out the procedural requirements for the formation and membership of an RTM company and its acquisition of the right to manage premises containing 2 or more flats held by qualifying tenants. There is no substantive requirement, no just and convenient qualification, and no discretion. Once the procedural requirements have been met, an RTM company is entitled to acquire the right to manage. There is no scope for the landlord to resist except on procedural grounds. At 21, so rather than taking on responsibilities crafted by the FTT in a management order, the RTM company takes on management functions created by the relevant lease or leases. There's a helpful summary there of the distinctions between the 2 schemes. I think now's a good time to turn to Corsand, which we'll see both parties refer to, but in different contexts. You have both the Upper Tribunal and the Court of Appeal decisions in Corsand in the bundle. The estate in question in that case had a relatively complex layout. There were a number of buildings, various parking areas. There was a grassed amenity area. It's on the Plymouth Sound. If you've ever come in on the ferry from Spain.
You can't miss it.
Yes, you can't miss it.
It's an old gun battery, I think.
Yes.
Yes.
Yes. There's a good description of this in the Upper Tribunal decision. But for present purposes, it suffices to note it's an estate, a bit like this one. We have a mixture of houses and flats and blocks and communal areas, so on and so forth. An application in that case was made to appoint a manager under the 1987 Act. And Mr. Woodhead was appointed as the manager for 3 years in respect of property described simply as the Fort Corsand. And a plan was attached to the management order that identified the property, and it extended to the whole of the estate. The landlord appealed on the grounds that the LVT, which was then the relevant tribunal, had exceeded its jurisdiction under the scheme because the property within the order included premises to which Part 2 did not apply. And to give an example, the grassed amenity area, which it was common ground, was not within the curtilage of any of the blocks. So the issue was, can the LVT included in the management order land in the ownership of the landlord that is not residential buildings, is not within the curtilages of those buildings? And the Upper Tribunal held that in the context of the 1987 scheme, it was inescapable, is the word used, that a management order granted in relation to premises that included easements over other land, so there were rights of way, of course, over the estate, over this grassed amenity area, that it might authorise a manager to carry out functions that include works to that servient tenement, so to the grassed area. Those would be functions in connection with the management of premises. And in reaching that view, it was a decision of the then President. His attention was rightly drawn to the Court of Appeal decision in the Maunder Taylor and Blackweir case I mentioned a moment ago. And it's probably helpful to have a read of that. It starts at the bottom of page 401. And it is paragraph 16 I'm inviting you to read, which carries on over the page.
We're now in the Court of Appeal, are we? No.
No.
No, we're not.
No, this is the upper tribunal.
Yeah, thank you.
It's the quote from the Court of Appeal's decision in Maunder Taylor that I'm taking you to.
Sorry, which paragraph?
It's paragraph 16 at the bottom of page 401, but it's the quote from Maunder Taylor at the top of the next page that's really important. And you'll see that part of the reasoning in the upper tribunal, which is the first line of paragraph 17, is it was accepted in that appeal that premises, for the purposes of section 24, included incorporeal rights, so rights in the present case included access over the common roadways and footpaths. That line of thinking by the President, George Bartlett in this case, is the same line of thinking that the same judge takes in Gala in the upper tribunal. And that reasoning leads us to, which you see at the bottom of that page, so that the last third of paragraph 17, it seems to me for this reason to be inescapable that a management order in relation to premises that include easements may appoint a manager to carry out functions that may include works to servient tenement. Those would undeniably be functions in connection with the management of the premises, so on and so forth. So it's that reasoning by analogy that the respondent in this case says should be applied to section 96(1). So this decision is subject to further appeal to the Court of Appeal. That decision's over a couple of pages at page 404. They had dismissed the appeal. They endorsed the President's decision. They note that the words "in relation to" requires a causal link or nexus between the functions to be carried out by the manager and the particular premises, but the functions are not confined just to the building and its curtilages. That is the reasoning the respondents say should be applied, as I understand it, to the 2002 scheme. And it suffices for present purposes if I just take you to page 411. There are two short paragraphs, paragraphs 33 and 34, that really summarise the Court of Appeal's take on this. If I can just invite you to read those on page 411.
So you say this is a wide meaning because it's a different scheme?
Yes. Yes, we say the decision in Corsan needs to be seen in light of that particular statutory scheme. The tribunal oversees the process. There's no automatic acquisition of rights. It's a fault-based regime, and a fault-based regime justifies a wider meaning being given, because if the landlord's at fault in respect of the block, the landlord's probably at fault in respect of the wider estate as well. The purpose of the scheme is to protect the interests of the lessees against that poor management, and that purpose might not be achievable under the 1987 Act unless you can grant the manager rights in respect of something beyond just the premises.
But it's a different scheme, I think, more importantly, in that it enables the tribunal to transfer some but not all of the rights, and it's not limited to the rights or the obligations on the landlord under the lease.
No, that's right. And in fact, one of the great things about the 87 Act is that if you have a scheme that doesn't work because the leases just aren't drafted very well, this is a solution to it to make it work for the landlord as well as the leaseholders. So it's not always an application by leaseholders dissatisfied with the landlord, but there are a number of solutions. Sometimes a variation application to vary the lease would be better. But yes, it's flexible, my lady, in exactly that way. Now, if the tribunal couldn't extend the management order to cover those ancillary parts, you'd also have the slight oddity that you'll have seen this as a multi-block scheme. That was section 21.6 says, 21.4b, that says you can have an application in respect of 2 or more premises. So you might make an application in respect of all the blocks on an estate, but if the order can't then include land outside the curtilages of those blocks, the manager would still be managing the landlord would still be managing the estate, even though you had a manager in respect of all the blocks. So it doesn't work in the context of a scheme that's designed for multiple blocks. And the RTM scheme is very firmly designed for a single block. It's also worth noting that it's such a wide jurisdiction, and again, this is the point, lady, you were making, the management order can provide expressly the landlord may not do X, Y, and Z. The landlord must cooperate with the court-appointed manager, and to the extent it doesn't, it can be brought back to the tribunal for the tribunal to take action, or if need be, to take it up to the upper tribunal, and then one would have contempt proceedings. You can't have that in the first-tier tribunal, but you can transfer up. So there's enforcement powers, there's teeth. None of that exists in the RTM scheme. So I say you can't safely apply Corsan and the logic in respect of in relation to by analogy. The other thing with the respondent's case, and I'm going to take you back to page 328, section 96.1. Is it leaves us asking, what is the purpose of section 96.1 if it's to be construed so widely? The only purpose of section 96.1 is to limit the functions that would otherwise pass as a result of sections 96.2 and 96.3. That necessarily means that there can be management rights under the lease that are wider than management rights in relation to the premises. Otherwise, what's 96.1 doing there? But on the respondent's case, all the rights under the lease are the rights in relation to the property, so there's no scope for the former to be more extensive than the latter. So I say that's another difficulty with their cases. 96.1 appears to have no function, certainly in any examples I've been able to think of. And the reason it's there in my submission is to achieve the purpose of the Act, namely that the right to manage company acquires all the rights it needs to in relation to the premises being the building itself or the part of the building, but no more than that. So that is how they achieve that statutory purpose of acquiring rights with respect to the block, but not the estate.
And the reference there to any part of the premises, how does that link in with the the definitions of what's self-contained?
If so, relating to the whole or any part of the premises, if one, it's easier with a paper copy, but if one compares section 96(1) with section 72, which you find on page 308, you'll see that the chapter applies to premises if they consist of a self-contained building or a part of a building. So you can claim the right to manage, but if you had a structure where you could
But the part has to be very separate.
It has to be capable of separate developments, redevelopment.
And have separate services.
It doesn't have to have entirely separate services, but the services have to be able to be separated in a reasonably easy way.
Services.
Yes.
Yeah.
But 72(1) says there are premises, and the premises can be part of a building. But
Yes.
section 96(1) says you can have management functions relating to the whole or part of the premises. So if the premises are a part of a building, can you just apply this in relation to part of that part?
Well, I think probably what that's getting at is there may be management functions under the lease that only relate to. There may be management functions under the lease that only apply to some of the occupiers, for example, some of the parts of a building. I'm trying to think of an example. One example might be if some of the units are affordable housing and some are private sector, and there are services that are available to the private sector lessees that are not to the affordable housing lessees, which may strike you as rather unfair, but is not an uncommon feature. And there you'll have separate schedules. Some of the services are management functions only provided in respect of part of the premises, because only some of the leases of flats in the premises would have the benefit of those services. I hadn't considered that point, my lady, but that's my initial response. If I think of a better response, I'll report back, if I may. So that is our broad response to the respondent's case. If I may, I'm going to turn to the third of my 5 points, which is to turn to the meaning of premises and appurtenant property, and how are we to construe the scheme on the appellant's case. And you'll have seen that we present several options for that. We've looked at section 72. You may be on page 308 already. We were just looking at it. Section 72 is under the heading Qualifying Rules. And we have this definition, we have a description of premises that the chapter applies to them if they consist of a self-contained building or part of a building with or without appurtenant property, and a number of other matters that we don't need to concern ourselves with today. And it's that description, with or without appurtenant property, that you'll have seen is described in the upper tribunal decision in Gala as not being terribly clear, and we can probably all agree it's not wholly clear what is meant by with or without appurtenant property. There is no definition of premises. You'll see it's a small p throughout the Act. It may be that the definition of premises is fundamentally provided by what is stated in the claim notice. You've seen that a notice has to be served on the landlord claiming the right to manage the premises. It must specify the premises. That's section 80, subsection 2. So if a valid claim notice is served, whatever is said in the claim notice may define the premises. But what is said in Gala is, this is in the upper tribunal, that section 72(1)A is to be read such that the appurtenant property does not need to exclusively appertain to the premises, so it can include the wider estate over which rights are enjoyed, and therefore the right to manage over the wider estate is acquired. And the logic of the definition is that the premises includes the appurtenant property. So what the upper tribunal did in Gala was read section 72(1)A as it applies to premises if they consist of a self-contained building with appurtenant property. If there isn't any appurtenant property, then the premises is just the building, but if there is appurtenant property, it comes with the building automatically. That is the construction that's put on it in Gala. The respondent says that is wrong, and our alternative case is also that that is wrong. Because on our alternate case and on the respondent's case, all the words with or without appurtenant property do is say it doesn't matter whether there's appurtenant property or not, the premises is the self-contained building or part of a building. My primary case is on the assumption that the reasoning in Gala that's also been followed in other cases is correct, namely that the self-contained building will come with any appurtenant property, but then we have to decide what is the appurtenant property that is being referred to. And appurtenant property is defined at section 112, page 339. Appurtenant property in relation to a building or part of a building or a flat means any garage, outhouse, garden, yard or appurtenances belonging to or usually enjoyed with the building or part or flat.
Sorry, where is that?
Page 339. And quite understandably, part of the reasoning in Gala as to why appurtenant property is to be read widely is because it says belonging to or usually enjoyed with. And or usually enjoyed with runs the same difficulty as in relation to, in that it could be given a wide meaning or a narrow meaning. It's worth noting that it says there the building or part or flat. The or part is to reflect that it could be that you're claiming the right to manage a part of a building. The or flat is because this definition of appurtenant property is used in other places. One example is section 77, subsection 5, which relates to qualifying criteria, what types of leases, how leases of outhouses and things that go with a flat are to be treated. So it has other purposes, this definition. The problem is twofold. A, there isn't a definition of premises in the Act, but Gala says the premises is, as I say, the self-contained building with the appurtenant property. But secondly, that word premises is used throughout the Act. And that takes us to the authority of Triple Rose, which is at page 567. I think it would be a fair description of Triple Rose to say it's the most comprehensive consideration of the RTM scheme that there has been to date. It's a decision of the Court of Appeal. It was, in fact, a number of conjoined appeals, and it related to the fundamental question as to whether a right to manage company can acquire the right to manage in respect of more than one building or part of a building. And the answer was no. It's important in the context of Triple Rose to bear in mind that before the Court of Appeal said no, the upper tribunal had said yes. And the reason that's important is because we're going to go on to look at some other authorities from the upper tribunal at the time at which it was thought that the upper tribunal decision was the last word on the matter. So I just placed that marker there. In concluding in Triple Rose that premises must mean the same thing wherever that term is used in the statutory scheme, the Court of Appeal deals with this at paragraph 62, which is page 587. If I could invite you to read paragraph 62 on page 587. If premises mean the same thing wherever they are used in the Act, then whatever is the premises for the purpose of section 72 is the premises for the purpose of section 96 and 97 and all the other provisions. It's fair to note, of course, that Triple Rose was determined a number of years after Gala. One reason to note that, of course, is you may have seen in Gala that in Gala the right to manage company had acquired the right to manage 2 buildings and nobody took the point. Now, the only way to avoid the difficulties apparent in this case and other examples is to read the premises as being the building, perhaps together with property that's exclusively appurtenant to it, but not as being the premises and all other property over which the leaseholders enjoy rights under their leases, whether or not those are enjoyed with others. It must mean something less than that, and I'm going to look at some examples in due course about that. But a number of inconsistencies and difficulties flow from any other reading, if one accepts that premises must mean the same thing throughout. If I can just run through some of those examples, and we'll return to a couple of them in a bit more detail in due course. I'm starting on page 309. Now I'm going to, and I hope it won't be too difficult, rattle through these relatively quickly, but I'm going to come back to a few of them. The section 73 subsection 4 point is one that I will return to. Now, section 73 specifies what is an RTM company, and at subsection 4, it provides that a company is not an RTM company in relation to premises if another company is already an RTM company in relation to the premises, or any premises containing or contained in the premises. There's 4 premises in there, if you were counting. They can't all be, logically, references to the premises that mean the same thing throughout the Act. But plainly, the point is that if you have an RTM company in respect of a block, you can't have another RTM company in respect of that block. That's perfectly logical. The problem is, if the premises is the block plus the estate, as they say Settlers Court is, construed literally, the effect of section 73.4 is no other block at Virginia Quay can acquire the right to manage, because there is already a right to manage company in respect of the estate, and they have to acquire the estate as part of the block.
I don't think it's argued that I don't think anyone has argued that the rights to manage cover property which is exclusively for the use of somebody other than the tenants in the right to manage block. They're only seeking to extend it to shared.
That's absolutely right, Malaysia, but the problem is, I mean, the Sale Court is the block next door to Settlers Court. If Sale Court want to exercise the right to manage, and the definition of premises is Sale Court, but tied up with that as the appurtenant property is all of the estate, Settlers Court has already acquired Settlers Court plus all of the estate, the management rights in respect of it. So read literally, section 73.4 says Sale Court cannot acquire the right to manage in respect of their block, because when they exercise the right to manage, the premises automatically includes the estate. And there is already a right to manage company in respect of premises contained in the premises. I'm going to come back to this point, if I may, because it's been considered quite a few times. There's been various ways found around this problem that are relevant to how we consider premises, because the courts have had to grapple with this quite a few times. And the way in which they find a solution is essentially akin to treating premises as just being the building and not including the estate, and avoiding what Gala says. And they come after Gala.
And they must, I suppose, proceed on the assumption that although the premises is just the building, the right to manage includes rights under the relevant leases of flats within that building to manage other parts of the estate. Rights or duties, as the case may be. I mean, it'll usually be duties.
the broad approach is to say the premises are just the building and a personal property should be treated as just that, appurtenant, but the premises is the block. The problem is that Triple Rose says premises means the same thing throughout, and Gala says premises is the block plus the estate. It doesn't sit together. If I may, I'll come to those authorities in a moment. If you look at section 81.3, which is over on page 316, subsection 3 attempts to achieve a similar thing to section 73.4, but in relation to claim notices. It's essentially the same quandary as the section 73.4 point. At section 94, page 327, this relates to what happens when the right to manage company acquires the right to manage. On the day of acquisition, the incumbent manager pays over to the RTM company all of what are described as the accrued uncommitted service charges, which broadly is all the money in the service charge account. The definition doesn't matter. Section 94, subsection 2, provides that the amount of any accrued uncommitted service charges is the aggregate of any sums which have been paid to the person by way of service charges in respect of the premises. If the premises is the block plus the estate, what this says, at least read on the face of it, is that all of the service charges received from all the leaseholders on the estate in relation to the estate will be paid over to the RTM company.
When you're using the word estate there, you're meaning the common parts, not the other self-contained blocks.
Correct, my lady, yes.
But what's missing here then is any way of determining which part of the uncommitted service charges under a lease where service charges apply are charged both for the block and for the common parts, how you work out which uncommitted service charges should be passed over and which shouldn't.
Lady, that's right, but the other solution, and it's the solution that I say, and I believe my own friends say is the solution, is that section 72, where it's talking about the premises with or without a pertinent property, is only referring to the premises. And if we take the premises as just being the building, all of these problems are resolved.
Why?
These problems are also resolved if we take a pertinent property as being just the property that is appurtenant to the building exclusively.
It doesn't seem to me to be resolved at all. What you're envisaging doing is splitting out some of the service charges, which you say relate to the premises, which is a subset of the service charges which the landlord or the management company will have been collecting, because he's been collecting service charges both in relation to what you describe as the premises and in relation to the common parts, because hitherto they've been managing all of it.
Well,
but now you're saying, well, not all of that is uncommitted service charges in respect of the premises, but how are you supposed to work out what is and what isn't?
The practical answer to that is if one looks at the lease, the service charges are payable under different schedules. So you have a service, you pay X percent of the block costs, you pay a smaller percentage of the estate costs. I'm summarising.
Is it kept separate by the landlord in different accounts if he's got a pool of money in an account?
My lady, yes. A set of accounts are included in the bundle. Page 277. In fact, if you turn to page 282, you'll see the estate cost schedule. Page 283, you'll see block costs for different blocks. You'll see separate schedule for car parks because they're a separate service.
There's no evidence, presumably, as to how typical that sort of accounting split is, although presumably some of the rules, the statutory rules about service charges would make it a regulatory requirement to be fairly specific about what is being paid for what.
There are regulatory rules that provide that you have to be specific about what's being paid for what.
Yes.
They don't require necessarily the accounts to be presented in this format, but I think it's almost the invariable position that if you have a multi-block estate where there is a difference between contributions to the estate and to the block, then they are split out. There are some instances where everybody pays equally. So you might have 2 blocks on an estate and everybody pays an equal share, and that means sometimes they have to pay for things to the other block. So it's not an invariable rule, but this is a very typical arrangement. In answer to my lady's point, there will be times where the managing agent has to get their calculator out to work out, and even now it is not uncommon for there to be disputes about what the uncommitted accrued service charges are, and the FTT sits and it goes through all the ledgers and it works out the answer.
Well, under what jurisdiction does it do that?
Thank you. Yeah, section 94.3, my lady, on page 327.
I realise there are a number of different arguments in play, but I thought the argument advanced against you was that the pertinent property included an easement over the common gardens, let's say, not those gardens themselves as part of the premises.
That was the reasoning in Gala as to why the pertinent property extends that wide. I don't think it's the reasoning of the respondents. I think the respondents say once you've acquired the right to manage, which comes in to section 72, we forget about a pertinent property, and what we're focusing on is section 96.1 and whether it's in whether the management functions are in relation to the block, and that's it.
They may make that argument, but Gala is in play as well.
Well, my lord, yes, quite so, and that's where we come to this definition of appurtenances and the meaning of a pertinent property, which is where I'm going to turn to very shortly. Just one other or two other mentions of problems, if I may. Page 329, section 97, subsection 2. This is expressly referenced in our written case. But literally, if premises includes the estate, as Gala says it does, that means my client is not allowed to manage the estate, even though it owes obligations to manage the estate to all of the other occupiers on the estate. When I'm referring to the estate, I'm not including the individual blocks. So that's the section 97.2 problem, if I can put it that way, and I'm going to return to that. The last example is section 103, subsection 2. In the interest of time, I'm not going to take you to it now, but that's another example of absurd results. That point takes time to explain, and if I can simply refer you to the interveners' submissions at paragraphs 7e to 11, and they start on page 129. In the interest of time, I'm not going to take you to them now, but if I can invite you to consider those as the last point on this.
So which section is this?
It's section 103, subsection 2.
Thank you.
And I'm sorry, page in the bundle?
The submissions in respect of that are on page 129. It's paragraphs 7e to 11 of the interveners' written submissions. We could easily spend half an hour just looking at that quandary, and I don't think it's a good use of our time this morning. The reason I've taken you to all those examples is to emphasise it's really important that we understand what are the premises. because the answer to what are the premises in Gala doesn't work. None of the parties before you say it does. So we provide those solutions. One solution is we read the premises as coming with the appurtenant property automatically, but we must read appurtenant property in a narrower sense. The second solution revolves around reading section 721A in a slightly different way so that it all has to be self-contained. The third solution is to say the words with or without appurtenant property just mean it's irrelevant and the premises is the block, and that's our third version, that's their primary case. The claim notice in this case, you don't have it in the papers, but it simply specifies that the right to manage is claimed in respect to Settlers Court and the address given. No issue about that. There is that issue about whether the appurtenant property must be specified in the claim notice. That may be the context in which you ask for the statutory instrument that sets out what must be in a claim notice. Both parties take the view that the claim notice does not need to specify any appurtenant property, because that's unlikely to have been intended. You'll see in the model form of claim notice that's in the supplemental bundle in the statutory instrument, it's not really set up for you to specify all the appurtenant property. And of course, certainly on the reasoning in Gala, well, this was your point, it includes all non-physical rights, it's rights of way, things like that. So how would you possibly specify all the appurtenant property in the claim notice? And this is a process that theoretically can be dealt with by leaseholders without the involvement of lawyers. So it's wholly impractical. That point was considered in Gala. You'll find it at paragraph 14, and as I say, the view was taken. It just comes automatically.
But what was the view expressed in Gala at paragraph 14?
Well, it's at page 476.
Thank you.
It's worthwhile reminding ourselves of the whole of paragraph 14. So you'll see there, next to letter D, it would be unsatisfactory if a claim notice had to specify whether or not it was made in respect to a pertinent property. That approach has been followed a number of times in subsequent cases. It's never been departed from. We don't invite you to depart from it. But it does mean, if you don't have to specify it, but it comes automatically, we need to understand what is meant by a pertinent property. And you might decide it is not, but if you decide and you agree that it's to be automatically included within the premises over which the right to manage is exercised and claimed, and premises means the same thing wherever it's used, it has wide-reaching effects that lead us to where we are now. Now, in our written case, at paragraphs 30 to 56, we set out the history of the term appurtenances by reference to a number of other statutory schemes, by reference to common law, and we set out the key authorities.
So your first solution is that paragraph 14 of Gala is right. The appurtenant properties automatically come with the self-contained building for the purpose of working out what the management functions are that are transferred.
Yes.
But you have to limit appurtenant properties to those exclusively used.
Absolutely right.
And the second solution is that the appurtenant properties are not included, it's just the self-contained block, And what this is saying is, if it's got appurtenant properties, that doesn't stop it from being self-contained for this purpose.
Well, on that second reading, it's irrelevant what the appurtenant property is for the purpose of the Act.
Yes.
Because the definition of appurtenant property in section 112 isn't engaged. The premises is the building or self-contained part of a building. We still have to think about what is appurtenant to that block, because the block isn't just bricks and mortar. Some things will come with it and will pass without express mention, and that's what I'm coming on to now. But it's appurtenant in a different sense, and it's easier if I illustrate it by reference to the cases, my lady. There's a number of different ways of formulating. This is on our principal case now, where we have to read the definition of appurtenant property at section 112 more narrowly than Gala says one does. At paragraph 30 of our written case, it's page 83. I set out, you can see the words in bold that I have added to explain what we mean. Another formulation would be to use the word exclusively. So appurtenant property in relation to a building means any garage, so on and so forth, or appurtenances exclusively belonging to or exclusively usually enjoyed with. However, I want to be really clear. I am not suggesting it is necessary to insert any words into section 112 to read it in the way that I say it should be read. I'm giving these examples to illustrate what I mean. I don't say that you need to insert words.
Well, your paragraph 30 looks as if it's inserting words.
It is inserting words to explain what
as I understand, you're seeking to spell out for the uninitiated what you say is there by implication.
Yes, my lord, absolutely. One doesn't have to add the words. What one has to understand is what the meaning of appurtenant is and appurtenances. And it has a long and rich history using very similar forms of wording to what is in the Act, and has been understood in a way different from Gala in a number of other contexts for centuries. And that is not something that the Court of Appeal or the Upper Tribunal in Gala was taken to. You may recall in Gala, the parties were represented by their company directors. There were no lawyers involved. There was not extensive legal argument about the history and the meaning of appurtenances, which is a peculiarly long history in property law.
But it's a meaning which you would have said was written into the DNA of the parliamentary draftsman.
My lord, yes.
But I can see that in this context, it doesn't make sense to include incorporeal rights, because what you're talking about is mowing the lawn.
Yes.
And you're not mowing the incorporeal right to walk on the lawn.
That's right.
Whatever maintenance or insurance has to be taken out relates to the lawn and the buildings, not the right to use them.
Absolutely. I can't remember which case it is. I think it might be Fencott, but one of the cases, that's the point that's made. You don't manage a right-of-way. You maintain the footpath. Now, we don't have time to run through all of the authorities on appurtenant property, and I don't propose to do it. I would like to take you just to the main one, which is Matthew and Campbell. It's at page 485. It was a decision under the 1967 Act which confers on a tenant of a leasehold house the right to acquire the freehold of their house and premises, where premises is defined as any garage, outhouse, garden, yard and appurtenances which at the relevant time are let to him with the house. Similar wording to section 112, but certainly not identical. No reference to or usually enjoyed with. The house in this case is a detached property with a garden, and also let with it in the same lease was a further area of paddock beyond the garden. So you have a house, the garden, a fence, a paddock. And the plan to the lease showed the boundary between the garden and the paddock. There was a wire fence. The question was the paddock included within the house and premises? The court had to consider, was the paddock a garage, outhouse, garden, yard, or appurtenance? At first instance, the court held that the paddock was included. On appeal to the Court of Appeal, that decision was overturned. It was not. And the court found that appurtenance was not to be construed strictly according to its original meaning of incorporeal rights, but to be construed to include land within the curtilage of the house, and the paddock was not within the curtilage. There's a passage in Lord Justice Goff's judgment at page 493 I want to take you to. I'm just going to highlight a few bits. If I could invite you in due course to read everything from the bottom of page 493 through to the bottom of page 497. It's too big a passage to read through now, but it really does give the full history of appurtenances. Looking on page 493, just under letter F, you'll see the original strict meaning of appurtenances required that the thing appurtenant should be of the same character as the principal subject matter. Therefore, land could not be appurtenant to land, and any attempt to make it so was void. That's the original strict meaning. Over the page 494, just below letter C, this strict meaning would yield to a context, however.
I'm sorry, is there a not missing in there?
Yeah, I don't understand that sentence.
Because as it stands, I can't understand it.
No, nor can I.
It must mean, shouldn't it?
Yes,
Should
not
not be of
Yeah.
the same character as the principal subject matter.
Yes.
Yeah.
Yes, I think that must be right. Land cannot be appurtenant to land. A right of way can be appurtenant to land. That was the original meaning.
Yes.
Over the page 494, just under letter C, this strict meaning would yield to a context, however, not only in a will, but also in a deed, as was shown in Hill and Grange. And then down at letter G, there, however, for what it is worth, it is to be observed that the word was appertaining and not appurtenant. Indeed, I think the strict meaning has so far yielded to context as to be really dead, and to be replaced by another, which is that all that passes on a demise as appurtenant is that which would pass without express mention. And I say that formulation, that which would pass without express mention, is a really helpful way to think about what is appurtenant property in the section of section 72.
Would pass without express mention in what? In the
conveyance.
In the conveyance.
So if one were to sell the property, what wouldn't need to be specified? What would be so obvious that you wouldn't need to mention it? There's an example in the Respondents case where they say, oh, there's complexities at the boundaries in terms of working out what's included in the building and what isn't. And one example they give is the porch outside the front door. And one might think that would pass without express mention. It's obvious. Whether it's inside a red line or it's not inside a red line, it's obvious that the porch is part of the block. What may not be obvious is whether the flower beds that form part of the general landscaping on an estate pass without express mention. By submission, they clearly wouldn't, because one has to look at the block in the context of the leases that are grafted out of it if you're buying the block. But it's a test that's actually remarkably easy to apply when you look at it. We don't need to deal with that detail here. The first-tier tribunal can go into a site view and, if there's a dispute, work out the answer. But it's quite an easy test to apply.
It's a very odd one, though, to define the meaning of a word by reference to what would be in a conveyance if the word wasn't there.
Yes, yes. But that is what this long line of authority says. And in fact, that's what's broadly said in trim. That's over the page 495. You've got the quote at letter C below. If I take you to the quote in trim, I'm looking at letter D, just under letter D, where it starts, and it is now beyond. it is now beyond question that, broadly speaking, nothing will pass under a demise by the word appurtenances, which would not equally pass under a conveyance of the principal subject matter without the addition of that word.
Yes.
But then further down, this is now just below letter E, that view, as far as I understand the authorities, has never been departed from, except that in certain cases it's been held that the word appurtenances may also be competent to passing corporeal hereditaments. Certainly no case has been cited to us in which the word appurtenance has ever been extended to include land as meaning a corporeal hereditament which does not fall within the curtilage of the yard of the house itself, that is, not within the parcel of the demise of the house. That confines appurtenances to the curtilage of the house. So curtilage is that is the bounds of what can be appurtenant. That doesn't mean everything that's within the curtilage is appurtenant, but it certainly sets a maximal extent.
How does that apply to a garage here, sir? Outside the building?
Yeah.
Well, the answer to a garage is if it is let exclusively to, for example, it's let to a flat, so you have a lease of a flat and it comes with it a right to use the garage, and that garage may not be immediately adjacent to the block, that it would pass without express mention, because it's tied up, it's inextricably bound up exclusively with that block.
Even
It can't be used by anyone
if
else.
it's outside the curtilage.
Well, yes, because
I mean,
the definition...
take the parking spaces in the Gala case, for example, which were, I think, outside the curtilage as such of either of the blocks,
Yes, they were
but
under
were
the other two
designated for
units.
particular block flat owners.
Yes.
It's quite a common feature where the garages are separate.
Yes, the distinction will be whether they're exclusively let to that particular flat or not. If they're exclusively let to a particular flat, they can't be enjoyed by anyone else, and they obviously come with the block. Because you'll note the definition of appurtenance includes express reference to garages.
I understand why you say it passes automatically, but that seems to be in conflict in this case with the other explanation, which is it has to be within the curtilage of the premises.
Within the curtilage is the maximal extent of things that will pass under the word appurtenance. But you've got to look at section 112, which says garages, yards, outhouses belonging to the premises, and that includes in that appurtenances, which will be other matters. So garages, of course, are specifically mentioned if they belong to that building.
Well, that was why I raised it.
Yes.
So we could forget about the curtilage.
Well, we can't forget about... We can forget about curtilage in the sense of it being... curtilage and appurtenance are not interchangeable. They often mean the same thing, but they are not interchangeable. But curtilage operates as a maximal extent of the appurtenances. And you've got to remember, in this case, the appurtenant property is defined as the garage, the outhouse belonging to the block, as well as appurtenances.
So are you saying that the garage or the parking space, which is also land, if it's exclusively used by the tenants, that somehow the curtilage of the block extends to that?
No, I'm saying that it will, within the context of the RTM scheme, it will obviously pass with the block. And it's really important to understand this definition in Methuen Campbell and in Trim.
Well, it might not. I mean, sometimes tenants can lease out their garage to somebody else to use.
Yes, but it's in proprietary rights, it's still theirs.
But if they then sell the flat, they might sell it subject to that.
If they sell the flat, all they could retain would be a lease of the garage. But I mean, I think it gets complicated if we're talking about a separate lease of a garage, because that would then not be included within the proprietary rights associated with the block. I think that's more complicated.
But I think what we indicate is I'm not sure that this definition of appurtenances, limiting things to the curtilage of the house, can be what's meant by section 112.
My lady, I agree it's not a complete answer, but that then takes me on to the next authority we should look at, which is Dartmouth Court, and that's at page 431. Because what they're looking at in Methuen Campbell is what passes with a house. We're not looking at what passes with a block, the different contexts. This is the point the respondents make. And the answer is that the meaning of appurtenances follows that theme, but it bends to suit the statutory context. Now, Dartmouth Court is an example of that, page 431. This concerned the 1987 Act, but not the appointment of a manager bit. This concerned Part 1, which is the rights of first refusal. So before the landlord disposes of part of the building or part of the building, if it's a relevant disposal, he must give notice to the leaseholders and give them a right of first refusal. And amongst other things, the landlord was granting a lease of the airspace above the building, which led to the question, is the airspace above a building appurtenant to the building? And the court in that case considers how far building includes its appurtenances, those that were passed without express mention, and they consider Methuen, and this is paragraph 55 on page 445. At paragraph 56, they say they don't derive any assistance from Methuen and Campbell. We have this concept of tenants' rights as attaching only to land which is enjoyed with the actual building itself. The point is, the meaning of appurtenance has this thread, it has this theme that it is limiting. It's limited in the land that will pass under the meaning of appurtenances. But it's important, I accept, that the meaning of appurtenance is construed in the light of the scheme in question, in this case the RTM scheme, and against the purpose of the 2002 Act. And Dartmouth Court is a good example of that. You have to consider the meaning of appurtenance in the context of the scheme in question. And I started off in my submissions taking you to the purpose of the scheme and the idea that it was to apply on a block-by-block basis, that management of the estate would stay with the existing manager or landlord. And as we've seen when you go through and look at the examples of the meaning of premises, the Act doesn't work if premises includes the entire estate as part of the appurtenant property. And that is why Gala is wrong. Appurtenant property must be something more narrow. And the question is, where do you draw the line? And the simple answer to where you draw the line is to read it as if it's referring only to property that is exclusively enjoyed by that block and the leaseholders within it.
Even if it's outside the curtilage of the block?
Even if it's outside the curtilage. It's a question of how do we read section 112. It's not a question of inserting words. It's reading section 112 against the statutory purpose.
So if we have a gym that is half a mile away, that the tenants of a block of flats have the exclusive right to use.
Yes.
That falls within the RTM meaning, does it?
Lord, it does. I mean, it's an extreme example, I hope you don't mind me suggesting, because if it's exclusively enjoyed by that block, why is it so far away? But yes. There's lots of other examples of the use of appurtenance in other schemes, in other statutory contexts, in our written submissions. I'm not going to take you to that now. They all differ slightly. They all do have that theme of trying to fit the statutory purpose and limiting the extent to something less than anything that you have rights in respect of.
And just so I understand your answer to Lord Burrows, that would be focusing, bringing the gym within the word appurtenances in section 112, is that right?
Well, yes.
Because it's not a garage, outhouse, garden or yard, naturally.
Correct. Yes.
Okay.
The alternative answer, my lord, is that under our alternative formulation, the formulation that respondents advocate, we'd be looking at section 96(1), and in relation to the block, you then have to work out whether that gym that's half a kilometre away is, whether management of that is a management function in relation to the block, and there that the answer may be less clear. I don't have a solution to that. I can see it could be argued either way, and a tribunal would need to work out the answer. But it's quite an extreme example for something to be exclusively enjoyed, but, you know, half a kilometre away.
Can I just ask a question about the point that my lady raised earlier on? If you have one fee which is charged to the landlord, which covers the narrow service charges in relation to the block, but also the estate charges, you showed us, I think it was section 93(4), that at the initial starting point, there's a mechanism that if it's not clear what part is accrued service charge and what part accrued estate charge, you can go to the FTT for resolution.
Yeah.
What about moving forward? Is there a mechanism whereby one can tell how much of what might be a unified charge under the lease is attributable to the service charge element and what to the estate charge element?
No, there isn't, because you have that dividing line. That's your point where the management parts ways between the two parties. And this is the point the respondents make. There isn't a mechanism in the Act pre-acquisition whereby you can determine the precise extent of the premises. Now, I say in most examples it's going to be really very obvious. We can all think of extreme examples which make it difficult, but in most examples it's going to be pretty obvious. It's not going to be difficult at Settlers Court. There's mention of a light that illuminates the car park that's attached to the block for which there's an electricity supply the block pays for. It's that sort of thing that it's probably not going to be worth arguing over, that you're left with in most practical examples. But that's what the respondent says. Well, there's no pre-acquisition mechanism, so that's an indicator that Parliament intended that you wouldn't have to work out that physical extent. And I accept that point, but there is an answer to it, which is, A, it's going to be arguments around the peripheries rather than the alternative, which they advocate for, which is we have a fundamental problem with managing the estates because my client has a massive shortfall that can't recover.
But why do you say it's only around the periphery? If the lease is drafted on the assumption that the landlord or the manager will be managing both the block of flats and the common parts, and everybody's lease is drafted on that basis. And now, initially on acquisition and thereafter, you're going to split those functions, then it's not to do with the periphery of it. It's working out how much of that charge was initially when it was put into the lease and now going forward, how much of that is to be devoted to the block and how much of it is to be devoted to the common parts.
My lady, with respect, I disagree. You have a dividing line for accounting purposes on the date of acquisition, and that's that process in section 94(3). From that point onwards, the money the RTM company spends on the bits that it is managing is the charge that it levies. The bits that the incumbent manager is spending on the estate are the bits that it levies. It's very simple. The only
lease doesn't contemplate
No,
but the management functions are split. That's what section 96, 1 and 2 does. It provides a perfectly neat solution in my submission to it, because you're just splitting the management functions. You're not splitting the covenants in the lease, you're splitting the management functions. So if the landlord will only spend money on the management functions it has retained, the RTM company will only spend money on the management functions it has acquired, and they will both levy a service charge using the same service charge mechanism in the lease. It works perfectly well. That is how it currently operates in many
The service
schemes.
charge function in the lease will be a unitary function.
Yeah.
But the necessary consequence of the Act, where an RTM has been implemented, will be to, whatever the lease may say, to require it to be split into two.
Yes.
And each party charges for that which they are doing.
Yes.
And if they overcharge for that which they are doing, then there's a lot of statutory
Protection.
ammunition there for tenants to go along, A, and get proper disclosure and proper accounts, and B, to challenge it.
Yeah.
Yes.
And if there is a dispute at the periphery, I mean, what you're going to get is either they both manage something or neither of them are managing something. The porch, the flower beds outside the block, whatever it is that they haven't managed to agree on. And if they're both managing it, one of them is going to be found to have incurred those costs essentially unlawfully, because that wasn't a management function under the lease, therefore the cost isn't recoverable. If you get to a position where nobody's managing that particular flower bed, then the landlord has rights under the statutory scheme to enforce the RTM company's obligation, that's section 97(1). And equally, if the RTM company says, well, it's not me, it's the landlord's meant to be doing that, the leaseholders have a direct covenant with the landlord and they can force the landlord to do it. So it's perfectly, the scheme works fine for resolving those difficulties. What the scheme doesn't do is deal with the problem in this case, where you have dual management and my client's managing the whole estate. The RTM company doesn't need to because we're getting on and doing it all. There is no mechanism for payment, which indicates that Gala is wrong.
Well, and also it's a scheme which contemplates that if one person has management, then nobody else can manage it.
Quite.
Yes.
Yeah.
Yes, I'm just to follow through. I think I was making the, on reflection, foolish assumption that there's a set payment charge under the lease. It's £100 and it covers two things, but in fact the charges are following the function, which is what you've just been explaining, that there's the upkeep of the lift and the upkeep of the flower beds, and you pay whoever comes to do that whatever they charge for doing that, and then you recoup it from.
Well, it's slightly more complicated than that in most instances, because you have an on-account charge. Yeah. So the sums will have been paid on account, but that's why you have the section 94(3) mechanism to split the sums that have been received. So you also have reserve funds, building up funds towards replacement of the roof. So that's why you have to split it out, because you will in fact have received sums in advance. That's
But
not to say, my lord.
But they must still be a proper pre-estimate of the future liability.
Yes, and you have statutory protection as to the charges that were levied before RTM was acquired and afterwards. There is one niggle, though, which is I accept, this is probably the point my learned friend would make against me, in a few situations you do have fixed service charges payable. But in that case, they're not payable in respect, they're not service charges. So it really falls out of all the statutory protections, because if it's a fixed sum, it's not a variable service charge. It's not a sum that varies in accordance with the services paid. It is then not a service charge. That's sections 18 and 19 of the Landlord and Tenant Act 1985. That doesn't arise in this case. It doesn't really arise in many cases at all.
And just so that I can understand, if you have a fund being built up for, servicing the roof in 10 years' time or something like that, I can see that at the point of the split, you have the section 94(3), division, which deals with everything that's happened up till then. Presumably, in that sort of case, the lease will make provision for building up a fund in advance. Is that how it works for the roof?
Yes, not always. Some leases don't provide for it, but it's very typical for there to be provision for a reserve fund You'll see in the accounts for this estate, there is a reserve fund for the estate, there is a reserve fund for Settlers Court, there is a reserve fund for the car park, and you build it up. All of that will be treated as part of the accrued uncommitted service charges, so the reserve fund will be paid over with all the other charges that are sat in the bank account for the property in respect of which RTM has been acquired.
And going forward, the tenants of the block will continue to pay into that reserve fund, but they will be paying the RTM company.
Yes.
The reserve fund still builds up.
Quite so, yes.
All right, thank you.
But they might also, the estate manager might also want to build up a reserve.
Yes.
Yes, for the estate, yes.
There'll be two. It'll be a split reserve fund with two different managers.
Yes. Which is exactly, in fact, at Settlers Court, that's what we already have, because they're in separate schedules, which is how it should be done, is you have a separate schedule for the estate, so on and so forth. But that isn't always what the lease says.
There's nowhere in the process of asking for participants or the notice that's given that requires the RTM to tell the tenants or the landlords what parts of the functions of the landlord under the lease they're intending to take over.
No.
It just says they're taking over everything that the landlord has to do under the lease in respect of these premises, but that's not actually what they are taking over.
This is the slightly interesting point as to whether you need to specify in the claim notice the appurtenant property. And as I say, there's a long line of authority starting with, you'll remember paragraph 14 in Gala that says, no, you don't need to, you just specify the premises. That view is then followed on in a case called Pine View. It's also, I think, in Fencott. And the view throughout state, you don't need to because that would be unworkable. The reason I say there's a niggle is it doesn't seem that that's what was necessarily intended, because if you look at the draft bill, and I'm turning to page 636,
Page
636. There is an explanatory note to clause 54, which is what is now section 72. Only the first half that's relevant.
Sorry, did you say clause 54 became section 72?
Yes.
Is that what you said?
It's the words in brackets. This can include other properties enjoyed by tenants under lease, such as garages or gardens, but does not have to. It's not wholly clear what that explanation means. It sort of suggests it wasn't intended that acquisition would be automatic and that you'd decide whether you acquire them. A further curiosity...
Sorry, just on that, and presumably in your claim form you could strip out other things, or can you not?
I don't think you can.
The current authorities are, you just specify the block, you do not need to specify the appurtenant property, it comes with it automatically.
I follow that, but could you put in the block, but not a garage, or it has to be everything, does it?
On the authorities, you should just put the block and nothing else. There are examples where people put the block and all appurtenant property, and that is a valid claim notice. Not specifying it.
What I was trying to put to you is, suppose they put the block brackets, but not a pertinent property, including, Lord Borough's gym down the road. Or
Yeah.
Could you do that?
On the authorities, the answer is no, because it comes with it automatically.
It doesn't seem very likely that people would want to do that.
No,
They might, in the instance of the gym, of course.
Yeah.
Anyway.
But then the claim notice becomes a little misleading, because as you started out, it indicates that actually the tenants will no longer have to have any dealings with the original manager, who they may well be very unhappy with. But in fact, that's not the case, that despite this RTM exercise that they're persuaded to go into, they are still having to pay service charges to the original manager, and the original manager doesn't have any choice, it appears, to then, even if it's uneconomic for them to send someone round to the blocks every week just to trim a few hedges rather than do all the work. They're kind of stuck with that, are they? And the tenants are stuck with them.
I'm not sure it's misleading, because the claim notice says that we're requiring the right to manage the block. It doesn't say we're applying to manage the block and all the estate. And the people know that they are paying estate charges and block charges. That's how the lease operates.
Well, not misleading then.
So that's my principal answer, is it's not misleading. But secondly, it's how the Act works. And thirdly, it can't work any other way. That's my case in this appeal. It just doesn't work any other way. But I've really drawn you to this explanatory note to make clear it isn't 100% clear how it was intended to be dealt with. It is worth noting this explanatory note, we're looking here in the draft bill, but this explanatory note remains in the Act as enacted. It's just that the brackets are taken out. And it hasn't been, I don't think, considered in any of these authorities on whether or not it needs to be included in the claim notice. The parties here don't say that the existing case law that says it doesn't need to be specified in the personal property doesn't need to be specified in the claim notice is wrong. That isn't because we necessarily take a completely firm view on that point. It's just because it doesn't arise in this appeal. It's another illustration of the difficulty of the Act, but I'm conscious I've spent quite a lot of time around this point. It's not central to the appeal. My broad point is we have to find a division between the block and the estate. I don't accept, which the respondent says, it will cause chaos. I say there are mechanisms for dealing with it because it's going to be peripheral points. In most cases, as in this lease, you have a schedule for block costs, you have a schedule for estate costs. They've been separately, the expenditure has been separately managed anyway. In most cases, it's not going to be a problem. There will be the examples where you don't have that split and where it has to be worked through. You're going to know that when you acquire the right to manage, and you'll be taking it on in the acceptance that if you can't reach agreement with your landlord, you're going to have to get someone to sort it out. But it's not a big problem to sort it out. What is a big problem is the situation in this case.
Well, your core point was a pretty simple one, is it's ridiculous to suppose that it was intended there should be two different companies managing the common parts without any right of contribution from each other.
Well, that's right.
And that works both ways around. You know, whether it's the RTM company, which doesn't have the income, or it's the landlord that doesn't have another bit of the income.
I mean, I'm sort of moving. I think we're jumping onto the absurdities point, which is my last point, but I'll return to that in a moment. I'm going to deal very, very quickly with my fourth point, which is the alternative constructions, because really we've dealt with that in other ways. If I can take you to page 93. In fact, page 94. 93 is our second position, which is that you construe self-contained such that a personal property has to be self-contained. You have our submissions on that. Page 94 is this point that a personal property is irrelevant. This is our third solution.
But does that mean that if there's a garage, it doesn't come, the right to manage the garage isn't included?
Well, Lord, it doesn't. What it means is that what you acquire all turns on section 96(1) and what is meant by in relation to.
Yes, I see.
I mean, the third approach is effectively saying the presence or absence of appurtenances is irrelevant to your entitlement to an RTM scheme.
Correct.
And you could say that's the drafter of the explanatory note had a rather half-hearted attempt to put that in another set of words that doesn't quite do the trick.
Yes.
In which case you're not looking to section 72 at all to see where there are some alleged appurtenances, which ones are caught.
Yes.
It's all a question of 96, isn't it?
Section 96(1).
Yes.
And the statutory definition in section 112 of appurtenance, a person property, is irrelevant for the purpose of this appeal.
Yes, because it's not mechanically used in 96.
No. The other helpful feature of this version that you see on page 94 is it's one that we both agree on. It doesn't mean it's right, but it's where our cases meet, is our third version is the same as the respondent's first. And then we're left with just dealing with what does section 96(1) mean. It doesn't mean we don't need to consider what the premises are. The premises will be the building, but what do we mean by settler's court, as is expressed in the claim notice? And we're still back to this question of what would pass without express mention with settler's court. Because we still need to understand what premises mean, but we're looking at premises then in the context that Dartmouth Court was considering it. The rather stricter understanding of what is appurtenant to the building. It's a very similar context. It's going to be something more narrow, and whatever that is, the management functions in relation to that are what pass. This approach is entirely inconsistent with the reasoning in Gala. The respondent's case is Gala produced the right outcome for the wrong reason. But this approach is consistent with the cases that you may recall I referred you to earlier on how to resolve that section 73 subsection 4 problem, being that you can't be an RTM company in respect of premises if there is already an RTM company in respect to the premises. And you can see that in a decision of the Deputy President in the Upper Tribunal in Fencott, page 461. And I'm looking halfway down, paragraph 33, where it starts, I do not accept that approach. That approach being the section 73.4 problem I took you to earlier.
Right, so that's saying that if it's true, as Gala said, that appurtenant properties can be shared one, then it can't be true that only one RTM can ever acquire the right to manage them.
Yes, but we need to look at this decision bearing two important things in mind. The first is, you'll see in the last sentence reference to an RTM company in relation to several RTM buildings. This was a decision before the Court of Appeal overturned the Upper Tribunal's decision in Triple Rose. So at that point, it was thought you could have an RTM company in respect to more than one block. Secondly, my other criticism of that passage is that there is express reference to the tribunal in Gala Unity saying you don't need to specify in a claim notice what your appurtenant property is. But paragraph 14 of Gala Unity also says that it really does matter whether or not the premises come with or without appurtenant property. The appurtenant property is included in the premises. So it's not entirely consistent with Gala, but it is consistent. That view as to how to solve the section 73.4 problem is consistent with the respondent's case and our alternative case, because you just ignore the appurtenant property. And it solves the section 73.4 problem. That view is also taken in a case called Pine View, which you have, I think, in your supplemental bundle 2, I'm afraid. And it's paragraph 61, if you have that available to you. It's probably not necessary to read it, but it's similar wording. It's the same judge. It's either 6 weeks earlier or later, 6 weeks later.
by plunging into the middle, I've missed which judge we're talking about.
They're both decisions of the Deputy President, Martin Roger, QC.
Oh, yes. Thank you.
What page is it, sorry, on the Pineview?
In Pineview, page 15, sorry, probably page 16 on your PDF version, paragraph 61.
Is it, so how does this paragraph 33 work where there really are shared appurtenances? Is he thinking there'll be joint management of the shared appurtenances?
Yes, it's a decision that comes after Gala, after the Court of Appeal's decision in Gala. Which, of course, he was bound by, whether he agreed with this or not, because he appears to depart from the reasoning to reach that conclusion.
If there can't be shared management and there are shared appurtenances, you end up with a sort of residual. Let's say there are 5 blocks, and all the blocks do an RTM separately. Is the original landlord or his service charge company just left with managing the shared appurtenances? I suppose he is. Because on your case, cases, there can't be shared management.
Correct.
Appurtenance only means that which is exclusively used. So if it's a garage that's shared between 2 blocks, it stays with the landlord under the lease.
Yes.
Yeah.
So in this instance, you have 10 blocks. If they all acquire the right to manage, they will all manage their own blocks and the stuff that they exclusively enjoy. FirstPort will carry on managing the estate. In the context of this development, there's a really good reason why that needs to happen, because there's not only 10 blocks, there's also 50-odd freehold houses who have freehold covenants that oblige my client to manage the estate.
So, sorry, I'm not sure I've understood this alternative argument. The alternative argument is that premises does not include the appurtenant property. Is that right?
Correct.
But you say that under 96(1), management functions relating to the whole or any part of the premises include management of appurtenant property.
Not in the sense of appurtenant property as defined in section 112, just in the sense used in Dartmouth Court, that you've got to understand what Settlers Court is, that it says in the claim notice.
Well, then there's a mismatch if it's not the same as the definition.
Well, there isn't a mismatch at all. Premises means the same thing throughout. That's triple rows. So for section 72, the premises is the block. For section 96, it's the block. And it's irrelevant for section 72 whether it is with or without appurtenant property as defined in section 112.
Right, but the management of the exclusively used appurtenances, you say, falls within management relating to the narrower block.
Under 96(1).
Precisely so.
96(1).
Because if relating to isn't limited to the block, section 96(1) doesn't have a purpose, because it's everything that is a management function under the lease. And it doesn't achieve.
But what about the outhouse or the garage on this?
Well, if they relate to the premises, then they will, if they are management functions relating to the premises.
Although the premises do not include the outhouse or the garage.
Correct.
So repairing that is not relating to the premises.
I think that would need to be answered on a case-by-case basis. It's not something that one could answer universally. It's going to turn on what this court decides in relation to means. In my submission, in relation to can be convenient shorthand for anything that's exclusively enjoyed by the premises. You may reach a different conclusion, but that is the way to give practical effect to Parliament's intention. That's the way that makes it easiest for the parties to understand, without having to go to the court, what it is that management functions have been acquired in respect of.
So you say the management functions relating to the building include repairing the outhouse.
If
The
it's
outhouse is
exclusively owned, if it's exclusively enjoyed.
But without engaging the definition of a pertinent property at all.
Yes.
Well, correct. Appurtenances does come into it only in the sense of understanding what are the premises. In the sense in Dartmouth Court, does the premises include the airspace? Well, that's irrelevant because you don't manage airspace. Does it include anything else that would pass without express mention? The porch outside the front door is part of the premises. We don't really need to grapple with the meaning of that because it's enjoyed exclusively with it. The point that respondents say is, well, theoretically, everyone on the estate has a right to roam the whole estate, so they might be able to stand under the porch and enjoy it. But it's fanciful to, when you boil it down, the answer is obvious with a bit of common sense. That's my answer to that.
But is the answer to the problem about all the blocks on the estate becoming RTM blocks, and therefore the landlord is left with the uneconomic role of mowing the lawn or managing the paths, that the landlord can subcontract that to the RTM or to the same company that the RTM is using?
Well, it can't subcontract it to it. It could, in theory, reach a commercial agreement with the RTM company that the RTM company will manage it on its behalf. What happens in practice, in many instances, is that if there's just a small bit left for the landlord to manage, they appoint the same managing agent as the RTM company, and the managing agent effectively manages it as one. It has two clients, and it manages it as one. That's a really common way.
But he has to split the cost, presumably.
There is notionally a separate demand from both. So I have to say, in practice, it often doesn't happen. There is one demand sent, but that is not right. It's quite useful in this regard. I'm not going to take you to it now, but there is a witness statement from Dr. Nigel Glenn, which was filed on behalf of the intervener, that sets out what can only be described as hearsay evidence, but from a number of their members, giving illustrations of how it works in different places. That's really helpful to understand how it works. The
RTM of, say, that all 5 blocks on the estate, or say there are 3 blocks on the estate, they all appoint a different. They all have RTMs. Each RTM appoints a different managing agent.
Well, in that instance,
then the landlord, who's left with an uneconomic residue of roles, can choose which can offer it round to the 3 managing agents.
The landlord can, but I would perhaps take exception to uneconomic, because providing services is never intended to be a with-profit service as such. In this case, you have a commercial manager their only interest is that they will take a management fee, but the estate still needs to be managed, so they will take a management fee. So it doesn't become uneconomic. It may become inconvenient in some extreme examples where everything on an estate is subject to an RTM and there's some tiny little bit of grass. But commercial considerations take over at that point, and pragmatic considerations. All this boils down to is that section in Hansard, really, that we looked at. This isn't set up for a statewide RTM. So to get a statewide RTM, because each RTM company can only be an RTM company in respect of one block, what the leaseholders do is they set up RTM Company A, RTM Company B, RTM Company C. All of them appoint the same managing agent, and to the extent that there's any common parts left, often in that situation, the landlord would appoint the same managing agent and they take effective control. But that is a way of getting around the limitations of the RTM scheme in a pragmatic way. And that is what the Law Commission have been looking at in their recent project, is how do we enable proper acquisition of the right to manage of an estate? And you'll find that in the Law Commission's consultation papers, which are in the bundle, and their proposals. But that isn't what the purpose of the 2002 scheme is. It's block by block basis, it's individual blocks, landlord retains management of the estate. And that may be unsatisfactory, but that is the only possible answer. in practice, parties in many instances find ways around these difficulties. Well, I have my last point, but I'm not going to be done before 1 o'clock, I'm afraid, which is the absurdity point.
You've got more than 7 minutes of absurdities.
I probably do, I'm afraid. I want to take you first of all to the sections in Benyon. It's page 601. And then over on page 603, just the very top paragraph. The presumption against absurdity is simply a guide to legislative intention and is therefore most likely to be successfully relied on where the alleged absurdity is not a necessary consequence of an otherwise cogent statutory scheme and cannot be justified on other grounds.
We really need authority for any of this. I mean, this is basic principle, isn't it?
My Lord, quite possibly not. The only other point I was making was at the bottom of page 605, which is the point that generally will avoid a construction of an enactment that otherwise that produces an unworkable or impracticable result. That's what I say happens in this case. We're left with an unworkable or impracticable result. It's just a presumption. But as the President himself accepted in Gala in the upper tribunal, the operation of the scheme on this point is not wholly clear. So there is scope to invoke. Now, we need to think about the practicalities of the estate. This probably informs what we've just been talking about, really. Page 258, you'll see a plan of the estate. Settlers Court is the red building on the top left of the page near the roundabout. There's an estate road which runs through the estate. There's a number of other blocks. The ones in red that are not Settlers Court are the affordable housing blocks. Some of them, Bridge Court, Keel Court, Sexton Court, Explorers Court, were built in a separate phase. And are not included within the count of there are 10 blocks on the estate that you'll see included in the written submissions. An interesting quirk of fate, I know this because I lived in Wingfield Court at the bottom in my second year whilst doing my law degree and watched them being built. There are then freehold houses, those are in Jamestown Way 1 to 55, you can see on the right-hand side, and a number of other houses. They enjoy the services provided in respect of the estate as well. And they enforce those by way of freehold covenants, again, with my clients as named manager. So that's the layout. There's roads, gardens, bin stores, parking, everything you'd expect on a large estate. There's 700 odd units. It's a substantial development. There's a photograph on page 259 that may not be terribly clear, but gives you an idea of the areas around it. Of course, what you have at the bottom of that picture is the River Thames. Included within the estate is the river wall, which is included within the maintenance obligations. So the estate costs are potentially substantial from time to time. And actually, you may have noticed it earlier, there's a helpful photograph on page 277, which is the front of the accounts, which shows you that sort of riverside walkway. It's a fairly expansive area. So that's the context of this particular case. The other document I want to introduce but not dwell on is page 230, because that is where you find a sample lease for Settlers Court. Unless it would be helpful, I don't propose to take you through it. Suffice to say, it's in fairly standard form, and you'll see on page 231 reference to the Part A proportion, the Part B proportion, so on and so forth. So we have estate costs, water costs, block costs, parking costs. And a list of services in the schedules that follow, and a single payment mechanism for payment of all those proportions.
And which of those proportions do you say relate to the RTM, and which to the U?
Broadly, everything in A is an estate cost, and that would remain with FirstPort. Everything in B and C are block costs, and they would remain with the RTM company. I cannot recall, because the site view on this case was in May 2018, where the layout of the parking was. In this instance, it's basement parking space costs, and I think the basement is under Settlers Court and is exclusively enjoyed by it. If that's right, it will be an RTM company service, but I reserve my position on that. One has to go and look at it. So that's where you find the lease. I then want to go on to a few examples of absurdity which are set out in our written case and the respondent's response. It's now a good time for me to pause. I am nearly there, but I anticipate I need another 15 minutes or so, 15 to 20 minutes.
We'll resume at 2 o'clock.